Well, hello, and welcome to another exciting edition of Coffee with Stephen. This particular video blog references, of course, the regular blog that was contained in the email this week, and specifically, it talks about a court case, one that was just put up to an appellate court in the District of Columbia. It's called Wren versus the District of Columbia, and many of you have probably already heard about this. It happened last week. It has to do with concealed carry in our nation's capital. Okay, now it's important. All right, it's an important case, and it does have some larger philosophical implications when it comes to concealed carry. It doesn't have direct bearing on where most of us live here in the Ninth Circuit, but it is important to look at it and understand, well, the beginning of what we see is now a judicial temperament, okay? One of the things that I mentioned in the blog, whenever freedom manifests, whenever there's a spark of light, we need to acknowledge it, we need to embrace it, okay? Individual sparks may very well get extinguished, but sparks taken in collectivity, that can create a bonfire, and that bonfire can have a transformational effect across the entire country. We've seen it with the decision that many of you were paying attention to in San Diego regarding the preliminary injunction on large capacity magazines, and now we're seeing it at the DC Circuit Court of Appeals. Look, effectively what happened was in the District of Columbia, they have a licensing scheme for concealed carry that's very similar to the licensing scheme that we have in California, okay? They refer to what we call good cause, they refer to as good reason. Essentially, in order to exercise a fundamental right, a Second Amendment right, to bear arms outside of your home, you need to petition the government and you need to essentially convince the government that you have good reason to do so, okay? And typically the government would say, no, you don't. And as a result of that, there was a court case. And this court case ultimately went up to the DC Circuit Court of Appeals. And Judge Griffith of the DC Circuit Court of Appeals said that this entire scheme is antithetical to the Second Amendment. Okay? That an individual has an enumerated right to bear arms. And as such, having a licensing scheme that demands you essentially get permission from a magistrate is antithetical to that right. And struck it down. Now, there's no way of knowing whether this is going to ultimately survive. As many of you know from following Peruta, there's always the possibility of an en banc review. This was nothing more than a 3-judge panel. And of course, there's always the potential for a petition up to the Supreme Court. Whether or not they would hear it, that remains to be seen. But regardless, this is another incident of the judiciary looking at concealed carry laws, looking at gun laws and saying, wait a minute, this violates the principles of the Second Amendment. It's very, very important, okay? Whenever we have a victory, we must embrace it. We must nurture it, and like I said, even if it ultimately is overturned or extinguished, at least it starts to show us that the judicial temperament is starting to change, okay? And that's important. That's important for all of us. It's important for our fundamental understanding of freedom. As always, stay vigilant, train constantly, train consistently, train with purpose. As we always say, you absolutely have the right to bear arms. Most of you know me, and most of you know that I absolutely adhere to that principle. But with all rights, come responsibilities. And the responsibility oriented towards the Second Amendment is a responsibility to train. If you have any questions about this blog, or if you have any questions in general, always feel free to email me at stephen@artemishq.com. I hope you enjoyed it, and stay vigilant, my friends.